Will come to order. Welcome back to everyone. Obviously, it's a great day for America, and we are dealing with Mr. Camp. Happy to have you. Please join us here at the table, and Ms. Chu and Mr. Levin, according to the outline that we have for panel one here. So, Judy, we're happy to have you. Please join us at the table here. Let me say at the outset, I want to first introduce a very good friend of mine who's visiting here today, David Ashwell. Sandy, climb aboard. Pull up the chair next to Judy there. We're happy to have you. My very good friend David Ashwell, who is in the corner over here, is someone Louise has met. He was a great producer, and his wife is director. Is Deb here? She's not. Well, anyway, his wife is, you can't turn on television without seeing an advertisement that his wife has produced. But David is famous in that he's responsible for the painting that's on the wall here, and you met him last December when he was here. And we're very happy to have you, David. I also will take just a moment to say that one of the things that he and I have been working on is he came up with the idea of an effort to help the Save the Children Foundation, which does $500 million a year of feeding and clothing children around the world. So he came up with the idea of doing portraits of prominent people when they were children. And the book is entitled Yesterday's Children, and it's going to be sold with the proceeds going to Save the Children. And just the other day, I got Shirley Temple to submit a photograph, which is going to be part of his project, which is going to be unveiled within the next year or so. So thank you very much and welcome. We're happy to have you here, David. We're here for consideration of three measures. We will begin on H.R. 3, and we have the distinguished chair of the Committee on Ways and Means, and other members who are here, Mr. Camp, and we have Mr. Franks, Mr. Levin, and my California colleague, Ms. Hsu. So, Mr. Chairman, let's begin with you, and we will, without objection, include any prepared statement that you have in the record, and we welcome your summary.
Well, thank you, Chairman Dreyer and Ranking Member Slaughter. Let me first say thank you for letting me testify before the committee today. I do have a prior commitment at 5:45, but I want to answer any questions that the committee and its members have before that time, so I'll keep my remarks very brief. As you know, H.R. 3 is an attempt to codify the Hyde Amendment, and I'm pleased to co-sponsor with my friend Lamar Smith an amendment in the nature of a substitute that reflects changes made to the bill in the Committee on Ways and Means. For that reason, I introduced H.R. 1232, which the Ways and Means Committee favorably reported, and that bill incorporated into the substitute makes the necessary changes to the tax code in order to make H.R. 3 workable and ensure that the intent of the Hyde Amendment, which has had broad bipartisan support for over 30 years, remains the law of the land. Last year, there was an unprecedented expansion of the federal government's role in the procurement of medical coverage and procedures. With that came an equally unprecedented involvement of the IRS and the tax code in health-related matters. H.R. 1232 continues a long-standing and bipartisan precedent of preventing taxpayers' funds from being used for abortion-related costs. And I'll mention just a couple of technical aspects of the bill before yielding back. First and foremost, according to the Joint Committee on Taxation, the legislation will have negligible effect on revenues. It is not a tax increase, despite what some may have wrongly suggested. It would not affect either the ability of the individual to pay for an abortion or for abortion coverage through private funds, or the ability of an entity to provide separate abortion coverage. It would not apply to abortions in the cases of rape, incest, or life-threatening physical condition of the mother. And it would not apply to treatment of injury, infection, or other health problems resulting from an abortion. The provisions marked up by the Ways and Means Committee do make specific and narrow changes to the tax code so that tax-favored dollars in FSAs and HSAs cannot be used to pay for an abortion. Similarly, the language prevents the cost of an abortion from counting toward the deduction for unreimbursed medical expenses. And finally, the provisions make clear that tax subsidies made available in the 2010 health law for the purchase of insurance cannot be used for policies that cover abortion. Simply put, this legislation is about making sure taxpayer funds are not used to pay for abortions, but does not affect the use of private funds. Thus, we're basically codifying the Hyde Amendment in the tax code. And again, I thank you for the opportunity to testify here today, and I look forward to answering any questions you may have.
Thank you very much. Ms. Chu?
Good afternoon. Thank you, Mr. Chair, for giving me this opportunity. I'm here today to testify on behalf of members of the Judiciary Committee to express my strong opposition to H.R. 3. This bill is dangerous, misleading, and harmful, and could negatively impact millions of Americans. Proponents of this bill will argue that this simply prohibits taxpayer funding for abortion, when in fact this extreme legislation goes far beyond current law. Because this legislation goes so much farther than where we are today, I strongly urge you to allow an open rule with amendments that protect women's rights. This bill needs to be thoroughly debated on the House floor and go through a fully transparent bipartisan process so that Americans understand how it will affect their lives. Because it certainly will affect their lives. Today, 87% of insurance plans cover abortion, a legal and constitutional medical procedure. H.R. 3 will raise taxes on all those Americans who have one of those plans but need help paying for the premiums. Millions of American families and small businesses would be ineligible for the tax credits that will make health care affordable. So either you have to pay a higher tax or be forced to switch from the insurance plans you currently enjoy. If this bill passes, if your insurance plan covers abortion, even if you ever even knew that, and even if you never used it, you could face a tax penalty. Depending on what kinds of tax benefits you're eligible for, it could be substantial. Since so many need those tax credits, in practice, this will eliminate insurance coverage for abortions, a legal and constitutional medical procedure. So what does this mean for a real family? Take a family of 3 working as an assembly lineman who loses his job when his manufacturing plant closes. Right now, he's eligible for the health coverage tax credit to help with the cost of his $13,770 premium. But because his insurance plan included coverage of abortion, even though he never even knew about this benefit and no one in his family ever used it, H.R. 3 would suddenly make him ineligible for the benefit and would cost him $11,236. Even if you use your own money to pay for an abortion, under this bill, you couldn't deduct it as a medical expense, whereas you can for every other procedure. Federal insurance coverage of abortion is already incredibly restricted. The federal bans on insurance coverage have been around for a while, but they are still troubling. All women, regardless of ability to pay, should have the health care coverage they need. But this goes farther, making permanent the provisions that prohibit a woman in Medicaid from getting the care she needs. This bill isn't about funding, though that's how it's being sold. It's about limiting access to abortion for women and putting so much red tape and bureaucracy in the way women simply just will no longer have a choice. The debate is about whether politicians sitting here in Congress should dictate the personal, private medical decisions of the American people. Current federal law prevents a woman from using insurance to pay for a safe, legal medical procedure if her insurance coverage is from the government. This bad law restricts her ability to make the best personal medical decisions for herself and her family. And if that weren't bad enough, the bill is dangerous for women's health. It lets Washington politicians dictate the personal and private decisions of American families. It restricts her ability to make the best personal medical decisions for herself and her family. Many things happen in pregnancy that are beyond a woman's control, so it's important to make sure every woman has coverage for the health care she may need. And that's why we need an open rule so that this extreme legislation can be improved. And that's why I have offered 2 amendments to protect women's health and their personal medical choices. And if I may, I'd like to just briefly summarize these 2 amendments. The first one is the amendment that addresses a severe oversight in H.R. 3. As it is currently written, the bill provides exemptions in the case of incest, rape, or a woman's life, if a woman's life is in immediate danger. But there is no protection for a woman with cancer who might die without the proper treatment and for whom every day, every week of treatment could be the difference between life and death. The fact that death is not imminent should be irrelevant. And that's why I'm offering this amendment that will allow an exception for women with cancer to receive abortion care under federal programs if they need life-saving treatments that are incompatible with continuing the pregnancy. Whether they are federal employees on Medicaid or women who purchase insurance plans from state health care exchanges, all women should have the option to pursue life-saving treatment before carrying a pregnancy to term. It's unconscionable and morally irresponsible to demand that women forego treatments that could save their lives, but that's just what this does. My second amendment is a clarifying amendment and should be entirely uncontroversial. It clarifies that doctors must fully disclose all medical treatment options to patients. This provision is already law, and my amendment will purely guarantee that the provision remains in effect under H.R. 3 because pregnant women, even at a hospital, may not provide abortion, should understand that all options are available to them and what they are for the health and the health of their baby. We must ensure that no one thinks that this bill gives medical providers a pass from telling women what their choices are, no matter their personal beliefs. That's not right, and it's not ethical. So my amendment reiterates this legal right to protect women and their health, and I urge you to allow it to come to the floor.
Thank you very much, Mr. Jones.
Well, thank you, Mr. Chairman and members, for allowing me to testify here this afternoon. I will just start by saying that our founding fathers believed that there were certain self-evident truths that were worth holding on to. The greatest of those truths in their mind was that the transcendent meaning of this gift of God called human life was worth holding on to. Our Constitution says no person shall be deprived of life, liberty, or property without due process of law. Thomas Jefferson himself said that, quote, the care of human life and its happiness and not its destruction is the chief and only object of good government. Protecting the lives and constitutional rights of our fellow Americans, Mr. Chairman, is why we are all here. But in 1973, the Supreme Court said the unborn child was not a person under the Constitution, and we have now witnessed the tragic deaths of over 50 million innocent little baby boys and girls who died without the protection that we should have given them. Now, some of this was carried out with taxpayer funds before the Hyde Amendment and other such laws were in place, and taxpayer funding could potentially recommence under the future of Obamacare. Mr. Chairman, forcing taxpayers to pay for the indiscriminate killing of helpless little babies is not good government. H.R. 3 is a bipartisan bill that takes one more step to turn America away from the tragedy of government-financed abortion. The bill forms part of the new majority's pledge to America, and Speaker Boehner directed that this bill receive the designation H.R. 3, quote, as, quote, one of our highest legislative priorities. H.R. 3 prohibits taxpayer funding of abortion across federal programs, except in cases of rape, incest, life of the mother, and therefore, contrary to some discussions in the press, this bill will not be a departure from the decades of implementation under the Hyde Amendment policy. Now, the second part of the bill, Mr. Chairman, provides necessary protection for health care workers who will not perform or refer for abortions as a matter of conscience. Those who believe that a pregnancy is a circumstance which presents with two patients, the mother and the unborn child, cannot in good conscience do harm to that unborn child and therefore should not be coerced into performing abortions, as could arguably be required under the current health care system that we're. Mr. Chairman, it is said that a government is what it spends. This legislation is really about whether the role of America's government is to continue to fund a practice that takes the lives of over 1 million Americans every year, despite the fact that the overwhelming majority of Americans, even some of those who consider themselves pro-choice, strongly object to their taxpayer dollars being used to pay for abortion. Mr. Chairman and members, Americans are now beginning to ask the real question. Does abortion take the life of a child? If it does not, all of this is simply a budgetary issue and we should stop talking about it. But if it does, then those of us sitting here in the pinnacle of freedom, in the chambers of liberty, are living in the midst of the greatest human genocide in the history of humanity. And some of it financed perhaps in the future with dollars over which we will have had direct control. So finally, Mr. Chairman and members, I guess I would just ask all of you this one question, and just to consider this with your hearts, the words of Abraham Lincoln, when he called upon all of us to remember America's founding fathers and their, quote, enlightened belief that nothing stamped with the divine image and likeness was sent into this world to be trodden on and degraded and imbruted by its fellows. May that be the commitment of all of us today. Thank you, Mr. Chairman.
Hello, everybody. It seems like a few months since we saw each other, but it's been a couple of weeks. I'm glad to be back. And so let me just talk briefly about this bill that was at one point going to come up here and then was delayed. I spent 4 years before I came to the Congress, or many of 4 years, implementing the Hyde Amendment. It was the law of the land, and whether I disagreed with it or not, it was my obligation. I was in the Foreign Aid Agency to implement it, which we did. I think we need to have some truth in packaging. This doesn't codify the Hyde Amendment. It goes well beyond it. Because this is not a matter of federal funding. It's a matter of how we handle tax treatment of health expenditures. Those are not the same things. And so essentially what this bill would do would be to affect the use of the tax credit in the Affordable Care Act, the small business tax credit, the itemized deduction, the flexible savings accounts, the health savings accounts. And so it isn't correct to say that it codifies the Hyde Amendment. That isn't correct. It essentially goes into the tax code and beyond appropriated funds. It is a tax increase for certain taxpayers. The reason overall it isn't funded as a general tax increase is because its impact differs from taxpayer to taxpayer. But there will be a tax increase. But let me finish by saying I think it sets a very worrisome precedent once you start on this path. Because next we may hear that there shall not be available in terms of the tax code a health treatment for any procedure that is evolved from stem cell research. That's what this says. That is something that would be appropriate. Or next we may hear that the employer's deduction for health coverage would be eliminated if the employer-based policy through agreement between the employer and the employee included abortion-related services. Or next we may hear that the employee deduction would no longer be available. So it really, with due respect, I finish, is not correct to say this codifies the Hyde Amendment.
Thank you all very much. I have no questions. To me, it's very clear. Mr. Sessions? I have no questions. Ms. Slaughter?
Thank you, Mr. Chairman. I'd like to ask unanimous consent, if I may, to insert in the record a letter from a physician in my district. If I could read it, it's just 4 paragraphs. My patient Carol was excited to give birth to her first child. Her husband was a Marine serving in Afghanistan. Sadly, in her second trimester, Carol learned the baby had a lethal anomaly. I probably should explain lethal means this fetus could not live. She and her husband made the difficult decision to have an abortion. That's when they learned that military health insurance they relied on would not cover the abortion unless Carol's life was in danger. Her husband was outraged. He had flown back from Afghanistan to be with her, and he angrily asked me, I'm over there defending my country, and they won't even take care of my family. H.R. 3 and H.R. 358 would extend and enhance the harsh restrictions on abortion coverage for military families to women all across the country. Women need access to affordable assurance that covers abortion because many women face the heartbreak of having to make the decision that this woman did.
Without objection,
I don't want to, I don't want to play the game that we're trying to make sure that no federal money's been spent on abortion. We've been saying that for 25 years. Everybody knows that by now. We shouldn't waste House time again. We are, 6, 8 weeks into this, or more than that. We haven't done a single jobs bill. But this debate is not about who values life. We all value life. Mothers and women are the nurturers in this world. And to think that lightly they do anything at all that would be untoward is, to me, unthinkable. And if you don't believe that, think about your own mother. This is about who values the Constitution. It's an attack on the bedrock principle of our nation. The fundamental belief that the rights and freedoms of an individual apply to all Americans, both women and men, and should be valued above all else. H.R. 3 would place unprecedented restrictions on a woman's constitutionally protected right to choose. Among other things, it opens the door to the IRS audits of rape and incest survivors. Imagine that. It's not bad enough that you have been a victim of rape or incest, but you have to explain it to the IRS. And who are we to be turning the IRS into abortion police? But we're saying to them that you have to have a receipt or papers or something from a legal proceeding in order to make sure that you didn't take advantage. How could we do that to people who've already suffered enough? I've been in 3 legislatures. It's always been men in blue suits, who are really pushing this. Not that they're ever likely to find themselves in any kind of position to have to make any choices at all. This type of burden is unprecedented and designed specifically to chip away at the rights of women. The practice of using state power to limit a woman's rights may be done in other countries, but it should never be done in ours. Whether you like it or not, the Supreme Court of the United States has declared a woman's right to choose is the law of the land. This legislation sets a dangerous precedent for undermining and restricting constitutionally protected rights and must be stopped. Thank you, Mr. Chairman, for the time.
Ms. Fox.
Thank you, Mr. Chairman. I have no questions.
Mr. McGovern.
Thank you, Mr. Chairman, and I want to associate myself with the remarks of the ranking Democrat, Mr. Slaughter, who I think said it more eloquently than any of us could as to why this is a dangerous road we're going down. I want to thank Mr. Chu and Mr. Levin in particular for, again, pointing out the hazards of this bill. And it's a bill that, while maybe there's a chance it'll pass the House, I doubt very much it'll pass the Senate, and it certainly won't get the signature of the President of the United States. And this is our first day back from 2 weeks in our district. And I don't know about you, but not a single one of my constituents talked about this issue to me. Every single one of them talked about jobs, the economy. They're worried about the Republican bill on Medicare. They talked to me about issues that directly impact their lives and the economic insecurity that they're feeling, and they want us to do something about jobs. And so I just find it somewhat astounding that first day back after 2 weeks, maybe your constituents, are different than mine, but my constituents want us to focus on the economy and jobs, and I hope we get about doing that soon. I yield back my time. Thank you.
Bishop. Mr. Hastings. Mr. Hastings.
I have a question perhaps Mr. Camp can answer for me initially, and that is, does this measure as offered distinguish between large corporations and small businesses?
With the bill, the tax provisions of the bill, and first let me just say that I appreciate the comments that have been made. I do think it's somewhat ironic that we are now showing this concern about the intrusiveness of the IRS when just last year the legislation that the then majority, the current minority, voted to put the IRS in charge of much of the nation's health care last year. But this would apply to the tax expenditure. It is about the tax-favored use of tax-favored dollars. That's primarily the focus of this legislation. So, and let me just say, there are HSAs, MSAs, FSAs that people use for a variety of medical conditions, some of them very sensitive, psychiatric care, rehabilitation, alcohol or drug rehab. Those also are sensitive uses of dollars. And in terms of the taxpayer audit issue that was brought up by the ranking member, no one would be audited because of the medical condition. They're audited for other reasons. And while I realize this is a very sensitive issue, but the government is doing this already in Medicaid and in the federal Employees Health Benefit Plan. So there's nothing new here. But my understanding of the legislation is that it would apply to the use of the taxpayer dollars. Yes.
So I take that as a yes.
Yes. As I said, my understanding is that it's the use of the dollars. It's not the nature of the entity.
Then Mr. Levin was correct, that it's sort of.
Mr. Hastings, would you like me to answer your question directly?
Please.
The answer is yes.
Thank you. Mr. Franks, you spoke twice about the Founding Fathers. Would you repeat for me what you said? And I ask really for information because I'm not certain that I understood what you said with reference to the Founding Fathers and babies.
Well, thank you. I basically quoted three different sources. One, the Declaration of Independence. It says, that we hold certain truths. We hold these truths to be self-evident, that all men are created. And I think that's what makes them equal.
They didn't talk very much about women at that time, did they?
Well, if you are suggesting that the Declaration doesn't apply to women, you can make that argument.
No, well, I often wonder myself how we got Founding Fathers without Founding Mothers, but go ahead.
The second one that I pointed out was that the Constitution itself says no person, and that incidentally does include women, that no person shall be deprived of life, liberty, or property without due process of law. Mm-hmm. Of course, the Supreme Court circumvented that by simply declaring the unborn child not to be a person, which is what the High Tribunal in Germany did, and it's what we did in the 1856, I believe, in the Dred Scott decision. We said the black man was not a person. Three terrible precedents that took away the personhood and subjected the victims to the worst kind of inhumanity. Thomas Jefferson said the care of human life and its happiness, and not its destruction, is the chief and only object of good government. Those were the Founding Fathers. I also quoted Mr. Lincoln when he made a speech to a group of people and reminded them that our Founding Fathers had a belief, that they had an enlightened belief that nothing stamped with the divine image and likeness was sent into the world to be trodden on and degraded and imbruted by its fellows. And I was making the argument that I think that should apply to the unborn.
Do you feel that in some respects some women may feel tread upon and feel degraded by virtue of this kind of legislation?
I think that women can feel degraded in a lot of different ways, but I think that if you look at, there's a lot of talk about it being a women's issue. The women in this country are much more pro-life than the men, because oftentimes an abortion is something done to a woman by a man for the sake of another man. So the idea that that men of character would stand by and just let women bear this burden, I think is a tragedy. Most of the time, abortion is done on behalf of a man, not because a woman wants to choose to take the life of her
I
child.
said in another hearing, and I'll continue to say it, and that is that I really think men ought to butt out of this discussion.
Well, half of the babies that die, Mr. Hastings, are little tiny women, and we should keep that in mind too. Nothing kills more women.
Understand what you said?
I said half the little babies that are aborted are little tiny women. So we got to keep in mind that you're protecting men and women here. They're just infants at the time.
Yeah, but
And
you're missing my point.
I guess I am.
As much as you talk, or I, or any other person that is male, about this awesome undertaking that a woman may choose, we really, I don't believe, are psychologically equipped, and I know we're not physically equipped to understand the dynamics that women are confronted with when they have pregnancies, and that ranges through the ages, not just all the way up to rape and incest. And it's for that reason that I feel that the discussion is best left to those who may either have had the experience or understand that experience better. I don't know two people that were more tolerant than my grandmother and my mother. But I do know that both of them knew an awful lot about people that had botched abortions, and they were white and black in the halcyon days of segregation. And I just don't think we ought to hearken back to an era where people took unsound practices to remedy problems, in some respects, in a lot of them, thrust upon them by men. And toward that end, I stand by the fact that I think men ought to butt out.
Well, the only thing I would respond, Mr. Chairman, is that I would hearken back to a day when the term manhood included the courage to protect innocent children from being killed, even if someone that they thought, if somebody just considered it a matter of choice. There was a time when men stood up and said, we're going to protect all the innocent in our society.
Thank you, gentlemen.
Thank you.
Gentleman has yielded his time. I appreciate that. Gentleman, Mr. Woodall.
I do not have a question, Mr. Chairman.
Thank you. Mr. Polis?
Mr. Sanchez, Mr. Director, so Mark from Chicago, Illinois.
Without objection. Thank you. Gentleman yields back his time. Mr. Nugent? Mr. Webster? None at this time. Okay. I want to thank each of the members who have taken time to appear today on behalf of H.R. 3. I want to thank this panel, and you're now excused. Next on the list, we have the gentlewoman, Ms. Baldwin, if she is here. I would next go to anyone else from the Committee on Judiciary, the gentlewoman Sheila Jackson Lee. Showing they are not here, we will continue to move to the Committee on Ways and Means, the gentleman, Mr. Crowley. Others who had asked to give testimony today include the gentlewoman, Ms. Holmes Norton from the District of Columbia. Gentlewoman, please feel free to come to the table. And obviously, any prepared remarks she had would be included in the record, and I welcome the gentlewoman from appearing at this time. Gentlewoman is recognized.
Thank you very much, Mr. Chairman. Yes, indeed, I will just summarize my remarks and submit my prepared remarks for the record. I appreciate the opportunity to appear before you today, Mr. Chairman. they close the door, it would help.
If we could hold on just a moment, please, and I would instruct the clerk if she could please call. Thank you very much. A gentlewoman, Ms. Lee from Texas, would also be asked if she would like to join the gentlewoman. We have room at the table. If we'll hold, please, just for a second. Gentlewoman, Ms. Baldwin, if you'd like to join us also. Thank you so much. We'll shut the door. It's a little bit difficult to hear, so we're going to try and listen up here. Gentlewoman is recognized.
Thank you, Mr. Chairman. I appreciate the opportunity to testify before you today, especially since I was denied the opportunity to testify before the Judiciary Committee, even though this bill contains a provision that uniquely affects my district. So I appreciate your indulgence. If I may say that we've always been good sports in the House, and common courtesies like the right to testify here, as I requested the right to testify, the Judiciary Committee would go a long way, it seems to me, toward helping us to get things done in the House. I oppose the harsh anti-choice bill before you, and it's hard to imagine it surviving the Senate and a veto. I say the same for a District of Columbia provision that peculiarly finds its way in a federal bill dealing only with federal matters and federal funds. That would be reason enough for the Senate to reject this bill and for the President to veto it. I have great respect for my own anti-choice constituents and have always had great respect for members of this body and other Americans who differ with us on the matter of choice. The people of the District of Columbia ask for the same respect for themselves and their own views on this controversial matter. In our country, we allow this matter to be handled at the local funds when local funds, at the local level when local funds are involved. We do it under the most American of federalist principles, that the federal government does not intrude on local matters, a first principle of federalism. This bill really piles on the district. The 2011 continuing resolution already contains an annual provision that keeps the district from spending its local funds on abortions for low-income women in the District of Columbia. The majority must want to make sure it doesn't have to make its case on an annual basis. We know of no rider in the history of riders on the District of Columbia appropriation that the Congress has ever sought to make permanent, particularly on an unrelated federal bill that crosses the line into autocracy by dictating to the District of Columbia that it may never again spend its own local funds on reproductive choice for low-income women, unprecedented in more than 200 years of United States history. This is akin to a taking of local funds by the Congress and simply saying they're ours for these purposes, even though you raise them in the District of Columbia. Although the District of Columbia wants to spend these funds on a purpose that is not illegal and not unconstitutional. The only reason for ceasing to keep the city from spending its local funds in this way is a disagreement by some members of Congress with a majority of my constituents. So it tries to deem the District of Columbia as part of the federal government for purposes of this bill. Mr. Chairman, we will not allow our rights to be deemed away. The city granted home rule to the District of Columbia in 1973. It laid out conditions on that home rule. It stated it in writing. It laid out no conditions relating to disagreement between some members of Congress and the local jurisdiction that it was granting democracy for the first time in almost 200 years of American history. There simply is no principled way to take back democratic government based on policy disagreements that are always left to state and local governments. I'm asking to strike this non-germane and offensive provision, offensive to every principle of federalism, so as to permit the district, like every other local district, to spend its local funds as it chooses. The majority says it supports limiting the federal government's power and devolving that power, wherever possible, to states and localities. Here we're speaking about a policy long ago devolved by the founders themselves to states and localities. This bill does the opposite of the principle on which the majority has been, says it has been acting during this term of Congress by using federal power to snatch local authority and local funds from the District of Columbia and its residents. I ask the majority to practice what it preaches and allow the District of Columbia to use its own local funds as it chooses, just as you and your districts use your own local funds as you see fit. And thank you, Mr. Chairman, for your courtesy.
Thank you very much, Ms. Holmes Norton. I'd like to next go to the gentlewoman from Texas, Ms. Jackson Lee.
Mr. Chairman, thank you for your courtesies and that of the Rules Committee. Allow me, first of all, to associate myself with the remarks of Congresswoman Holmes Norton and to support her efforts here today. I'm an eternal optimist, and I frankly believe this is a particularly unique day when we are asked as Americans to stand united as Americans for the very special occurrence that occurred that really showed how great America is. And no distinction of Republicans or Democrats, collective fighting to seek justice, and through Presidents Clinton and President Bush and now President Obama, we have ended the life of the face of terrorism. That makes me an optimist. I think today, as I discuss this legislation, I'm still optimistic because I think the American people want us to work together. They are not asking us to propose legislation that is extreme and divisive, but also I have to respect your faith, your morality, your integrity, and the differences that you may have on your own beliefs. That is what democracy in this Congress is all about. But I do think it is dangerous to interfere with women's health. And I think it is further a question as to whether or not what we're doing today is strengthening the middle class or creating jobs. I started on the Judiciary Committee, Mr. Chairman, some years ago with one of our colleagues, Congresswoman Pat Schroeder. I was a much newer member, and I remember going through this journey at that time, the question of a woman's question of choice, what we call then the manipulation of words on partial birth abortion. That was not really the process. It was a medical procedure that saved the life of the mother. And we had this debate about the women's health and the health of the mother and how important that was. I remember, I think, Congressman Slaughter, on that time, I think Congresswoman Schroeder and myself may have been the only two women on the Judiciary Committee on the Democratic side, and I don't believe any on the other side. It was a very emotional time. We had women come and testify that they had no intent to terminate a pregnancy, but for protecting their opportunity for further births, and also doctors testified for their life. So I have amendments that I think are restrained and frankly address that question. And I'm an optimist. I believe it's important, though we may be thinking of a closed rule, to really comply with the Constitution as you've asked us to do. My first amendment is to ensure fundamental rights. It is what the Republican majority has asked us to do. A woman's right to make decisions about her own body. and as well to take into consideration a number of legislative initiatives. The Church Amendment, for example, I believe that was in 1973, that talked about the protecting of the religious or moral beliefs of those who provide or refuse to provide abortion services. H.R. 3 goes beyond that. I don't want to interfere with someone. I have St. Joseph's Hospital in my district. I don't want to interfere with someone's rights and belief. But this amendment asks the Attorney General to certify that this legislation would not violate a constitutional right of a woman's right to decide what happens to her own body, primarily the Ninth Amendment, which has been upheld by the Supreme Court. And I think that is important because my colleagues who have come in, and now the majority, have asked us to ensure that with our legislation, that oath must include the obligation to ensure that we're respecting the fundamental rights that the Constitution guarantees. The Supreme Court has declared that a woman's right to make decisions about her pregnancy is fundamental and that government burdens on that right can violate that right. I think that is an important amendment that should not violate any privilege or anyone's faith or anyone's integrity. My second amendment is to protect a woman from severe, long-lasting health damage. The bill accepts provisions of the bill, or the bill does not cover, where the continuing the pregnancy could result in severe and long-lasting damage to a woman's health, including lung disease, heart disease, or diabetes, or the inability to procreate, to give birth in the future. Every year, 10 to 15 million women suffer to severe or long-lasting damage to their health during pregnancy. So this language specifically speaks to severe and long-lasting damage. And I think that is an enormously important amendment to ensure. H.R. 3 does not codify the Hyde Amendment and is more extreme than the Hyde Amendment. This amendment reflects the 1978 version of the Hyde Amendment by incorporating an exemption for severe and long-lasting damage to a woman's health in continuing a pregnancy. And the amendment is supported by the American Congress of Obstetricians and Gynecologists, and women must receive the best health possible. Again, I am not here to challenge your faith, the integrity of your decision, but I do believe that outside of this room, there are individuals who have rights that are being violated by H.R. 3. And although we may not have been successful as we move through the Judiciary Committee, I know that the Rules Committee reflects the values and views of all of the members of Congress and all of America. On a day like today, when we've been called upon to be good Americans and Americans that celebrate the braveness of our men and women on the front lines, I do think we can come together and find a solution for the women who cannot speak for themselves and are not in this room. Mr. Chairman, I'd be happy to answer any questions on this.
I thank the gentlewoman. I also note, the Chairman notes that the gentlewoman, Ms. Moore, is also here, and I would like to yield at this time to the gentlewoman from Wisconsin, Ms. Baldwin.
Thank you, Mr. Chairman. You know, there's one question that every woman in America should be asking right now of our new House majority, and that is why, instead of focusing on job creation and bolstering our economy, are you so intent on taking away my rights and my choices? With unemployment at 8.8% nationwide, what my constituents and other Wisconsinites want to know is, where are the jobs? Nationally, nearly 6 million women are unemployed. However, instead of creating jobs for millions of women who are looking for work, the new majority priorities seems to be launching an all-out assault on women's rights. Women comprise half of the workforce, but are paid only 70 cents for every dollar that a man makes. Rather than working to close this pay gap that affects half the American workforce, the Republicans prioritize this measure that undermines women's equality. Despite promises throughout the midterm elections that the new majority in this Congress would focus on job creation and bolstering a struggling economy, the bill before us today again fails to deliver on this promise. In fact, I believe this bill could further exacerbate our economic crisis by forcing millions of Americans and small businesses to face tax increases. My colleagues, can we agree that this tax increase will not help bolster our economy or create more jobs. If there's one message I've heard loud and clear from my friends on the other side of the aisle, it's that tax hikes result in jobs lost. I hope that we can agree that small businesses are the engines of our economy. Over the past 17 years, small businesses generated 65% of new jobs in this country. That is a trend that we must work to foster and not hinder. So let's not put American businesses in a situation where they have to literally decide between providing comprehensive health coverage for the women they employ or face a tax increase and therefore perhaps hire fewer workers. Mr. Chairman, although I oppose this extreme and intrusive legislation for a host of reasons, I believe that the least the majority can do is ensure that small businesses and families will not face a tax increase during these difficult economic times. And my amendment that you have before you does just that. It ensures that hardworking Americans and entrepreneurs will not see a tax increase or face the prospect of job losses because of this Republican bill. I urge my colleagues to rule my amendment in order, and I yield back my remaining time.
I thank the gentlewoman, not only my friend, but also a colleague of mine, for coming and taking time to be at the Rules Committee today. The gentlewoman, Ms. Moore, I would tell you that earlier I had ruled that without objection we would take anything that you would like to bring to the committee for a prepared statement, and that is so ordered at this time. Gentlewoman is recognized.
Well, thank you so much, Mr. Chairman. And in the interest of time and the consideration that this committee has given me, I would like to put my complete statement in the record, associate myself with my colleagues here, and speak briefly and extemporaneously to my amendment. I just want to offer my amendment that would put a halt to the implementation of H.R. 3, the Taxpayer Funding for Abortion Act, unless the Secretary of Health and Human Services could certify that the American public, that this bill would not dramatically and disproportionately reduce access to comprehensive health care coverage for low-income women. Now, just let me interject here at this moment that I know the author, Chris Smith. I'm a friend of the author of Chris Smith, and I have no doubt about his sincerity and I know that he would not want an unintended consequence of his legislation to cause lack of access and certainly perhaps death to poor and low-income women. And this is why I'm seeking the certification, because if you're Gwen Moore and you have a lump in your breast, you go through to the attending physician's office, your employer's health insurance, you go and seek medical care that way. If you're a low-income woman who only has these exchanges or Medicaid, where do you go? And with all of the strictures that are placed in this bill, even strictures that would not be limited to life-threatening situations or health-related issues, I would say that this could be a real barrier to access for poor women. So I would submit my statement to the record and say that I think a real unintended consequence of this legislation would be to deny low-income and poor women access to primary health care that they would receive through these exchanges. And with that, I would yield back.
I thank the gentleman and each of you not only for your testimony. We will now refer to the committee for any questions. Woman, Ms. Fox.
Thank you very much, Mr. Chairman. I have no questions.
Thank you very much. Mr. McGovern.
Thank you, Mr. Chairman. I want to thank all those who have testified here today. I support all your amendments. I hope they'll be made in order. I'm not quite sure that they will be. In fact, if I were willing to bet, my guess is they won't be. But nonetheless, they're important amendments. And I just want to reiterate what I said before. I mean, it is baffling to me why we're bringing this bill up in the first place. It's not going to go anywhere in the Senate. And the President, I want to ask unanimous consent, Mr. Chairman, to insert in the record the statement of the administration policy in which the President says if the President is presented with H.R. 3, his senior advisor would recommend that he veto the bill.
Without objection.
I mean, rather than be immersed in these old ideological battles that seem to keep on making their way up to the Rules Committee on the House floor, we should be talking about jobs and putting people back to work. I mean, we just came back from a 2-week break. All people were talking about is jobs and security. To the extent they were talking about other things, they were frightened by the changes in Medicare that my colleagues on the other side of the aisle have been proposing. But it's all been about the economy and jobs, and people want to get through this difficult time, and they're expecting us here to show some leadership and to raise these issues and to try to figure out ways to make things better, and we're not. And look, I think this bill is bad for a whole bunch of reasons, but I also think it's bad because it's not going anywhere. It's just going to be a big ideological debate on the House floor, and for what? Instead, we should be finding ways to come together, as Mr. Jackson-Lee pointed out, and figuring out ways to move this economy forward. So I thank the panel, and I appreciate your comments, Mr. Jackson-Lee.
Governor, if I might, you struck 2 points that are crucial that have been raised by my colleagues as amendments, and I want to reinforce them. There are 2 principles that the majority ran on. They want to be constitutionally grounded and no new taxes. H.R. 3 is questionable as its constitutional grounding, and even with the veto of the President, may be subject to being overturned by the Supreme Court. But then there are actual tax increases. We're always talking about that, and there are no job creation. But I want to add this final point. At least in my committee, and that's why I was trying to reflect on what happened when Pat Schroeder and I were on many, many years ago on partial birth abortion. There were no women witnesses who had actually either experienced circumstances where they didn't have access to women's health on the issue of severe pregnancies or the fact of not being able to get this kind of care, to be able to say H.R. 3 will not impact my health if I had a circumstance where I was blocked. So there was not a factual basis, at least in the Judiciary Committee, and I'm concerned about that, because we did have witnesses who had actually experienced, back in those days, a pregnancy operation, if you will, that they call partial birth abortion. We actually listened to women about how that would impact. So I'm concerned, and I think it's important that we ask the constitutional question.
Yeah, I'll add one other thing that the GOP ran on, and that was they wanted to get government to butt out of our lives. And yet on this most personal, private matter, they want government to be in full control. And I find that somewhat ironic. So, again, I thank you very much for being here, and I yield back up.
I appreciate the gentleman's questions. Is there anyone else on the Democratic side that has any questions at this time for this panel? Seeing none, are there any Republican members that have a question for this panel? Seeing none, I want to thank each of you for taking time to be with us today. Duly noted that you not only were, if you'll just leave that right there, we'll come get that, Congresswoman Moore, and we'll make sure that gets in the record. Thank you. We appreciate it. Thank you very much. This panel is now excused. This closes the hearing for H.R. 3. The No Taxpayer Funding for Abortion Act, and I thank the members who took time to be here. I now would like to call up H.R. 1213, recognize the gentleman from the Energy and Commerce Committee, the chairman. Mr. Upton is here to repeal the mandatory funding provided to states and the Patient Protection and Affordable Care Act to establish American health benefit exchanges.
Mr. Chairman, if I might just say, just in the interest of time, knowing that these votes are starting at some point soon, I don't object at all to talking about both bills. Dr. Burgess is going to be. I would use us together as one team. You all look a little tired.
I thank you, Mr. Chairman. I would acknowledge the gentleman, Mr. Burgess, who's here, and please be advised that any written statement that you have would be included in the record without objection.
Well, thank you.
Recognized.
Thank you, Mr. Chairman. This bill is part of our effort to restore fiscal accountability to the federal government. In the rush to pass any kind of health care reform, the 111th Congress enacted a massive health care law that gave the Secretary of HHS unprecedented new authority. Although it got little attention at the time, one of the new powers is an unlimited tap on the federal treasury. Section 1311A of PPACA provides that the Secretary of HHS a direct appropriation of such sums as necessary for grants to states to facilitate the purchase of qualified health plans in newly created exchanges. Shockingly, the Congress gave an executive branch official the sole authority to determine the size of that appropriation. CBO told us that H.R. 1213 will reduce the deficit by $14 billion. However, it's important to note that the Secretary can literally spend hundreds of billions of dollars under this section without further congressional action. The legislative language is written so broadly that any activity facilitating enrollment in the exchange is eligible for funding. Any activity. The only restrictions on this unlimited appropriation are the Secretary's manners and imagination. Article 1, Section 8 of the U.S. Constitution gives Congress the power of the purse. If members of this body think that we should simply abdicate our fiscal management responsibility to the executive branch, I would ask them, why are we here? Repealing this fund is the best thing that we can do to protect precious taxpayer resources at a time of record red ink. Rampant spending on the federal credit card is unsustainable and dangerous. The federal government, as you know, will be borrowing 42 cents of every dollar spent for those grants. We're spending $58,000 every second on interest, and we are facing a $1.6 trillion deficit. Without this legislation, HHS will indeed be spending the money. At some point, the Supreme Court will likely rule on two federal judges' decisions that rules PPACA unconstitutional. My view is we shouldn't spend any of this money until we know what the decision of the Supreme Court will be. The endless spending is fiscally irresponsible and morally bankrupt. I respectfully urge the committee to support this legislation so that we can make progress in getting our fiscal house in order, and I yield back.
Thank you very much, Mr. Upton. We appreciate your being here. Mr. Pallone, please come up to the table. We are happy to have you with us. Mr. Burgess.
Thank you, Mr. Chairman. It's been, I think this is the first time I've been to the Rules Committee this year. I might say in the beginning that I like what you've done with the place. It seems so much friendlier and calmer than the last time I was here. So you're to be commended for providing the proper atmosphere to have these discussions. The bill that I have before us is H.R. 1214. This is a bill that is similar to what Mr. Upton just described. Within the what's now known affectionately as PPACA, the Patient Protection Affordable Care Act, which, just by the way, no member of this House on either side of the aisle really supported. It never went through regular order on our side. It was a bill constructed by the Senate, and truth be told, it was a bill constructed by the staff of the Senate Finance Committee. So it is not something that the House has or should feel that they have abject allegiance to, but here's one of the problems. 1214 identifies in Section 4101A of the Patient Protection Affordable Care Act funding for school-based clinics. Now, school-based clinics may be a concept of policy where I could be supportive, but here's the deal. This requires that the money be spent for building school-based clinics. 4101B, which is the staffing of school-based clinics, is entirely discretionary. How much did the President recommend in his budget that he submitted to Congress last February? $0. So we have the uncomfortable situation where we have mandatory funding for building these clinics and discretionary funding for staffing, and in fact, the discretionary funding was left out of the President's budget. There are spending items where Congress may deem them so worthy that they need to be on automatic pilot, but really that ought to be the exception and not the rule. The mandatory spending in the Patient Protection Affordable Care Act has been the subject of discussion for months, and the very arbitrary nature of the way the Senate went about designing some of these programs that they felt, the Senate felt, worthy of advanced appropriations and others not. The funding needs to be examined, and to the extent possible, if it's found wanting, it needs to be reclaimed. H.R. 1214 takes a very small step in that direction. It's a very simple bill with a simple goal to get rid of some of the spending in the Patient Protection Affordable Care Act recklessly that was advanced appropriated in a very reckless fashion. Section 4101A provides $50 million in mandatory spending for construction and expansion of school-based health centers every year from passage to 2013. Now, we may agree that these are worthwhile, that this is a worthwhile policy goal, but let me just point out, from 2008 to 2011, the health centers received $2 billion in funds each year in discretionary funding. Under the Patient Protection Affordable Care Act, they received another $11 billion in authorizations. In addition, $1.5 billion was included in the stimulus bill, some of which could have been used for construction of these school-based centers if they were deemed to be of such criticality. The $150 million in grants under 4101A are for construction only. There's an express prohibition in the legislative language on these funds being used to provide health services. That is, it is expressly prohibited to hire a doctor or a nurse. You can build a clinic, you can put an exam table in there, you can purchase a thermometer and a sphygmomanometer, but you cannot have a doctor or a nurse to attend the patient. We've allowed schools to purchase land and construct facilities that may not ever be able to deliver care. That's why for health centers generally, Congress does not fund construction and land acquisition. We focus on delivery. In fact, for FQHCs, it may be said, if you build it, we'll fund the staffing, not the other way around. I'm not against the concept of school-based health centers or school-based clinic, but providing mandatory spending for construction without adequate safeguards that they will provide care is irresponsible. So, Mr. Chairman, H.R. 1214 is a step towards financial responsibility, and of course I'll be available for questions.
Thank you very much, Mr. Burgess. Mr. Pallone.
Thank you, Mr. Chairman. I understand that we're dealing with both bills now. And I do also have an amendment on the state exchanges, so I guess I'll mention that briefly as well. Let's throw it all in at once. The state exchanges are really at the heart of the Affordable Care Act. If you eliminate funding for the state exchanges, you're really kind of putting a dagger in the whole bill. So I understand that the Republicans want to repeal the whole bill. I'm not, trying to take away from, well, I am trying to take away from your effort in that regard, but my point is that this is such an important part of the overall bill that we really should have an open rule, because I know that members are going to want to discuss it because it goes to the heart of the bill. The other thing that I really wanted to stress, though, is that, I find it ironic because the Republicans say they're the party of small government and they're for states' rights, at least most of the time they say that. And the fact of the matter is that right now, almost every state, 49 states and the District of Columbia and 4 territories have applied for these exchange grants. If you basically say that the states aren't going to get the exchange grants, then you're pulling the rug out from the states. And what does that mean? Well, it means that they may decide to go ahead and run the state exchange on their own, but if they don't have any money to do so, either they're going to do a poor job or they're not going to have any kind of money to figure out what's the best way to do it, because we've allowed for a lot of flexibility in this. The whole idea of having a state exchange, which I would think would go to what you like, state versus federal, is that there should be flexibility and it should be tailored to the individual state. Well, if you take the grant money away from them, that's not going to happen. Some of them may just do a lousy job and not tailor it to their state. Or others might just say, forget it, we're not going to do it, in which case they'll simply be a federal exchange. So, I understand you want to repeal the bill. I understand you want to do everything you can to get rid of the bill. But I think this is a very short-sighted thing if you really believe that states should be able to handle things on their own, and if you want to avoid the federal government preempting the whole process.
Thank you very much.
Let me just mention my amendment briefly,
okay,
Mr.
please
Chairman,
do.
and then I'll talk a little bit about the school-based. The amendment basically says that we would have a GAO report, requires the Comptroller General, GAO, to study the impacts of exchange grants on allowing states to set up the exchanges. So the purpose of that would be to show that it's short-sighted, or whether it's short-sighted, I guess, to have the state grants be replaced by a federal system. Again, I think you would favor that because you probably don't like the idea of a federal exchange. Then, as far as the school-based health clinics are concerned, I know that my friend from Texas here, who is a physician and I admire a great deal, said that he favors school-based health clinics. And again, I don't understand this. Everybody says they favor school-based health clinics. We have now applications for these centers, these school-based health clinics, to build or renovate them from 350 applicants. 23 from applicants represented by members of the Rules Committee, including a lot of the Republicans. They're, again, not saying they're opposed to it, they're saying they don't want the mandatory funding. Well, we use mandatory funding for everything, all kinds of things under Medicare and Medicaid. To not use them here for something that Dr. Burgess says is important to him, I think is a huge mistake. These are shovel-ready projects. These school-based health clinics show that they work, and if you don't have the mandatory funding, frankly, it's not going to happen. So I would plead with all of you, get away from the ideology of whether you like mandatory funding. These things work. If you get rid of them, it's only going to cost the federal government more money because these kids are going to end up going to the emergency room. They're not going to have insurance, and it's just going to cost us more in the long run.
Thank you very much, Mr. Pullen. Let me just say I'm going to encourage the committee to make your amendment in order that you've just talked about. Mr. Sessions?
I have no questions.
Governor?
I want to ask unanimous consent to insert in the record the statement by the Honorable Maxine Waters on H.R. 1213.
Without objection, will be included in the record.
I'd also like to ask unanimous consent to insert in the record the administration's statements on both bills.
Without objection.
And on H.R. 1213, the administration statement says that the President is presented with this bill.
Without objection, that will be included in the record as well.
That he vetoed the bill. And again, I would just simply say, given that reality and given the fact that this is not going to become law, I would again urge my colleagues on the other side of the aisle to find ways to come together with the administration, with Democrats in Congress, and let's start talking about jobs.
Well, gentlemen, you'll
Ms.
just
Fox.
just for a question or just
I'm happy to, but
I'd just like to say that I had not seen my friend's amendment, but if it means it's a bipartisan effort, if we took your amendment, you'd support the bill, we might be interested in taking a look at it.
Ms. Fox?
Thank you, Mr. Chairman. I have no questions, but I tell you, when I hear the expression cost the federal government more money, it's sort of like scraping fingernails across a blackboard to me. Federal government has no money that it doesn't take from citizens or borrow or print. And so acting like the federal government has manna from heaven, which it then expends, is incorrect. And so I'd just like to say that there's no such thing as federal government money except that which is taken from citizens or borrowed or printed.
But with the gentleman, you and I always have this discussion, and I think it's a friendly discussion. It's about preventative care, and I always say the same thing, which is that when you have a school-based clinic, it's a form of prevention where the kids get primary care and they don't end up going to the emergency room. I think it's well documented that saves money in the long run.
Mr. Hastings?
Mr. Chairman, I ask unanimous consent to submit a September 16th, 2009, dear colleague, over the signatures of Joe Barden and Dr. Burgess and Kay Granger.
Without objection, what will appear in the record?
In addition, I then ask Dr. Burgess, notwithstanding your passionate approach to health-based clinics, school-based clinics, I thoroughly believe that you are strongly an advocate of school-based clinics. I hear you today saying that because no discretionary funding accompanied the measure, that is your reason for opposition. I just want to give you a couple, let me just give you one example without going into great detail. We provide money for the construction of airport towers, but we don't say anything in that legislation at all. And as Mr. Pallone said, we provide all sorts of monies without carrying with it this thing that seems to cause you to nuance from your expressions. You and your colleagues wrote to all of us that you'd like to draw your attention to a program operated by JPS Health Network in Tarrant County. I gather that that's your county, or Mr. Barden's, or Ms. Granger's. We believe this issue is so important that we've come together to share this information. And then you go on to say that JPS Health Network serves as the public hospital in Tarrant County and includes many community health clinics and school-based health centers. JPS provides a valuable service. So it would seem to me if the health clinics are built and there are JPSs that are providing the services, how do you nuance your opposition today versus your support September 16th, 2010?
Well, Mr. Hastings, with all respect, those things are true, and unrelated. If you just simply build the facility and you do not spend any money to hire someone to staff it, then what good have you done that school-age population? Look, I have tried...
Excuse me, Judge, just let me take my time back to follow up on what you said and go back to the airport tower. We are building one in West Palm Beach. We haven't provided a nickel for who will staff it. Now, that's federal money. So what's the distinction? I'm having trouble understanding.
Well, there's no distinction. If you want me to oppose your tower in West Palm Beach, I'll be happy to do so.
You can, and many have.
But let me just point out to you, I have worked for literally the last 6 years to get a federally qualified health center in the east side of Fort Worth, an area with one of the highest infant mortality rates in the country, similar to the country of Libya in East Fort Worth. Very difficult to get one. Why? Because HRSA tells me, we don't build clinics. You build it, we'll fund the staffing. And that has been the inherent difficulty. And I will also share this with you, and it has nothing to do with this legislation before us today. It appears to me, it occurs to me, it is my finding that after looking at these things for years, placement of these clinics oftentimes is done on political considerations, not based on need for public health, which then means that this cries out for congressional oversight. We need to do the authorization and then the appropriation and have the oversight over the activity. Otherwise, we're just handing money over to Secretary Sebelius to spend whichever way seems appropriate. And guess what? Sometimes those considerations are political and not based on public health, sensible public health policy.
Well, perhaps not you, Dr. Burgess, but certainly the Republican Party has advocated, and many members of the Republican Party have supported the elimination of earmarks, and I gather from your conversation that this school-based kind of clinic could be put in that category. And so then it's Secretary Sebelius today, but it'll be someone else tomorrow. Let me tell you why I think we've made a big mistake by eliminating that process. One, what winds up happening is bureaucrats will take on the characteristics of congresspersons and will be selective as they see fit with reference to the distribution. Now, there's nothing in here that suggests that these school-based clinics, if built, I might add, also carry with them construction, which also means jobs. I would argue to you that it's so important that we have these kinds of facilities for our children. And I support your September 16th, 2010 letter in support of them, and I categorically reject the position that you take today.
Will the gentleman yield?
Yes.
You know, we had a hearing on this, and, you know, I don't have all the information in front of me, but as I said, you have 350 applicants, nationwide, and 23 from the members of this committee. Now, I know that when we had the hearing, many of the applicants were in Republican districts, and I think one of them, I'm not positive if any of them were in Dr. Burgess's district, but many of them were in Republican districts, and the criteria was whether they were shovel ready, whether they were ready to go. It's the first time I've heard there was any suggestion that they were politically based in terms of their placement. I don't remember that coming up.
You should pay attention when I talk.
All right, I don't remember your mention.
Thank you, Mr. Chairman.
You know, again, one of the arguments that Mr. Burgess gave with regard to the funding was it's a capital side, but not the operating side. in school district budgeting and in most budget, I mean, the capital is always different than the operating. I mean, we currently have a lot of operating assistance for schools through Title I and IDEA and other programs, not enough in some of our opinion, perhaps too much in the opinion of others. We provide very little, hardly any capital assistance. We had a bill last year to provide some capital assistance to districts that I would have liked to seen pass into law. Here we have a form of capital assistance. Again, very different than operating assistance, but I don't understand really the argument about why the two are tied together. Districts who have the ability to operate these facilities either in partnership with a community health clinic or on their own might not have access to the capital funds to construct them. And in any proposal for capital construction, I'm sure they talk about how they run them. So I don't really understand what that problem is. There's a difference between capital and operating funding.
And that may be accurate, but why not use the $1.5 billion you gave out in the stimulus bill for community clinics and school-based health clinics? I mean, the country is in a fiscal crisis right now. And the fact that we're borrowing 42 cents out of every dollar that we spend really requires us to have a great deal more scrutiny over the expenditure of these funds. And Mr. Hastings Airport Tower may be constructed with no money put towards air traffic controllers, but I dare say somewhere in the President's budget, he budgeted for hiring air traffic controllers. He generally does. But in this instance, you're prohibited from using this money to actually hire someone to deliver the care.
Yeah, that's fine. I mean, this image that you're kind of evoking is a false one, and they're not building clinics that are going to be empty. As part of the proposal, of course, they're talking about how they staff them, and it could be school districts in partnership with community health clinics. I mean, anything that is built under this will be staffed. It won't remain empty.
Why wouldn't you do it the same way you do every other FQHC? Ask the community to build the clinic, and then you'll help with funding the staffing at the federal level.
Well, yeah, I will in just a moment. These are instances where they weren't able to. Capital, again, is very different than operating. I mean, it's a different scale of resources, and it's a one-time expense. It's an expense, frankly, that we all know borrowing is justified. I mean, any private concern that engages in construction, any family that engages in construction, seldom ever does that with cash. So too governments, when you build a road, when you build a school, districts bond. It's a very normal thing to borrow for. Operating is a more difficult decision about borrowing, but I think it's very clear with regard to capital. I yield to my colleague from Florida.
I'm just curious, perhaps one or all of the gentlemen could tell me, when you make the application for the school-based clinic, as you said, am I not correct that what you would have to do is show what you would afford as staffing?
Again, we brought this up in the hearing, and that was exactly the case. The main criteria was whether they were shovel-ready, but they did have to show that they had the resources to staff it.
Case closed.
And if I could just take a little of your time, because Dr. Burgess mentioned the community health centers. And again, I'm arguing with someone who agrees with me that community health centers and school-based clinics are a good thing, so I don't even know why we're having this argument. But I'll give you an example with the community-based health centers, because he mentioned it. I have one in my hometown. It was paid for because of the stimulus, Recovery Act. 14,000 visits in the last year. It's only been around since the Recovery Act. And what they do is they directly take the people from the emergency room at the local hospital. Person goes to the local hospital, they find out if they're qualified for the community health center. Once they do, they put them in a computer, they send them to the community health center. It directly takes the people out of the emergency room so they don't come back again, and they get the primary care at the community health center. That is going to save you so much money. I know it's not scored by CBO. We've had that discussion before, but you're talking about such a savings that's unimaginable compared to the low cost of caring for these people at the community health center or the school-based health center.
Yeah, but that has nothing to do with this bill. And if this language
was
so good, why didn't you include it in your bill?
Reclaiming my time.
Why didn't you do this out of your health care bill?
Mr. Chairman, reclaiming my time. I think that, one general frustration in the budgetary process that I've always had since I got here, both the Democratic and Republican budgets, there's no capital budget for the federal government. And unlike any other company that always looks at capital and operating differently, now, and I think the argument for Mr. Burgess, therefore, is confusing because it further conflates the capital and operating. They are two distinct things. There is a justification for capital investment. I think, in fact, the justification, frankly, for federal capital investment is enhanced if it's going to be local dollars that can run these programs. I mean, that's wonderful if we can simply finance the setup and it's sustainable at the local level. That's a good deal for taxpayers. If it needs some level of support over time and operating support, that requires an additional level of scrutiny. But it seems to me the easiest type of investment for us to make are capital improvements that are sustainably run at the local level. So I think this is a good example of effectively leveraging taxpayer dollars. Any response?
Again, if it was such a good concept, why was it left out of the Democratic health care bill that passed the House of
By
Representatives?
it, do you mean operating funds? Or
Well,
what do you
why
mean
was
it?
this language?
Yeah.
Why is the Senate only smart enough to come up with this language? Your bill did not.
We're not fighting over pride of authorship.
Maybe they're
I
smart
would,
sometimes.
Occasionally
Usually
the
they're
Senate
not.
comes up with good ideas. I mean, it's not that, I think that there's, like many of us who voted no or yes on the bill, there were
Federally
parts
qualified
of both.
health centers will fund not the construction, but the staffing if the local entity builds it. Why should this be different?
Here again, you have the opportunity to get a better value for taxpayer money by providing the capital side, capital is at a huge premium for school districts. It's very difficult. Many of them are at their bonding capacity. Many poorer districts don't have additional bonding capacity. And the district, in partnership with their community health clinics and others, will be able to sustainably run these going forward. I mean, it seems like a good deal all around.
It's a feel-good legislation that's not based in common sense.
Well, it'll help young people feel good and feel healthy and therefore continue to be able
hire
to
a doctor,
go to
put
school.
it in a vacant room that you have on the school campus. That will help the children feel
There's
better.
more capital infrastructure than a vacant room that's needed for a clinic to be able to effectively operate and provide health care services. And with that, I'll yield back.
Gentlemen, thank you very much for being here. We do have a vote on the floor. We have fewer witnesses, and we're hoping to work this rule out as quickly as we possibly can. So, Ms. Woolsey, Mr. Welch, please welcome to the Rules Committee. Welcome back to you, Mr. Welch. And let me say that if you have any prepared remarks, unless anyone objects, they will appear in the record, and we would welcome your summary so that we might be able to report the rule out. And I will say that we're hoping to be very generous when it comes to the issue of amendments. So, Mr. Welch.
Thank you very much. My amendment basically seeks to carve out the opportunity for states that have made application for incentive grants to have the opportunity to do that. About 13 states have done this, and they range, frankly, from red states to blue states. And obviously the underlying point of this legislation, the Upton legislation, raises major questions about the health care law that we passed last year. But what my amendment does is basically embrace the concept that if you allow states to experiment, like with IT and best practices, and also to use some of these state set-up exchanges, and that would have to be a decision that the state made, that they would still be given the opportunity to apply for funds up to $1.9 billion. We had to put an amount in here under your rules that would apply, but it would be under up to $1.9 billion to give those states the opportunity to basically apply for funds for these experimentation and incentive grants. There's not a finger on the scale deciding what would be the best way to proceed. That would largely be up to the state. So here's, I think, a fundamental question that this Congress and this committee has to decide. There's a big debate, obviously, about the health care bill that was passed last year. The majority of last year's Congress was in favor of it. The majority of this year's Congress, our House, was against it. But what I hope is that there's some common ground, that giving our states some opportunity to experiment is probably beneficial to the process. Because I find oftentimes the argument among my Republican colleagues is that, hey, let's let the states be laboratories of experimentation, see how it works. And you know what? Some states may go down a path and find out it really doesn't work. Other states may go down and surprise us and it does work. It doesn't bind us to anything. It just gives them the opportunity. So my amendment is to allow us to do that. Thank you very much, Mr. Chairman.
Ms. Woolsey.
Thank you, Mr. Chairman. My amendment has two sections. The first prevents H.R. 1213 from being enacted until after the Office of Management and Budget and CBO both certify that it will not reduce the availability of affordable health care coverage choices. And if it does, if OMB and CBO report back that access to primary care would in fact be limited, this amendment would stop the bill from becoming law. The second section on my amendment would establish a public health insurance option that would compete among private health insurance plans within the health insurance exchanges. This legislation, the Public Option Deficit Reduction Act, H.R. 191, was reintroduced in January, was projected last year by CBO to save the federal government $68 billion over a 7-year period. The CBO more recently scored a similar public option proposal in its March 2011 budget option report and concluded that enactment of a public option would reduce the deficit by $88 billion over 10 years. It's clear that the public option, at a time that we're looking to bring the budget closer to balance, would mean substantial savings to taxpayers. Mr. Chairman, implementing the public option would free up funding that the government could use to make coverage more affordable or to pay down the deficit. The public option was also cited by the Bipartisan National Commission on Fiscal Responsibility and Reform as a viable means to control health care costs, since it provides affordable alternatives to private plans. And actually, it's a surprise that this isn't something that Republicans who are supportive of states making their own decisions about what kind of coverage they would have for health care aren't supporting this. And it's also my thinking that if anybody's serious about either saving money or providing a choice to insurance, those who need insurance, would be actually supportive of making this this amendment in order.
Thank you very much, Ms. Woolsey. Appreciate your both being here. I'm going to encourage this committee to make an order amendments that comply with germaneness and the CUGO requirements. Are there any questions for our witnesses? If not, thanks to you both for being here.
Thank
and that
you,
will
Mr.
close
Chairman.
the hearing. And the chair will be in receipt of a motion.
Thank you, Mr. Chair. I move the committee grant H.R. 3, the No Taxpayer Funding for Abortion Act, a closed rule. The rule provides 1 hour debate with 40 minutes equally divided and controlled by the chair and ranking minority member on the Committee on the Judiciary, 10 minutes equally divided and controlled by the chair and ranking minority member of the Committee on Ways and Means, and 10 minutes equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule waives all points of order against consideration of the bill. The rule provides that in lieu of the amendment in the nature of a substitute recommended by the Committee on Judiciary now printed in the bill, the amendment in the nature of a substitute printed in the report of the Committee on the Rules accompanying this resolution shall be considered as adopted. This bill as amended shall be considered as read. The rule waives all points of order against considerations of provisions in the bill as amended. Finally, the rule provides one motion to recommit the bill with or without instruction.
You've heard the motion of the gentleman. Let me just say that we did make a request to the minority that there be a substitute submitted, and there was not a substitute submitted. And so if there are any other amendments, Mr. McGovern.
Mr. Chairman, I move the committee report an open rule for consideration of H.R. 3 so that all members have the opportunity to offer amendments to this unprecedented attack on women's rights.
You've heard the motion of the gentleman. Any further discussion? If not, the vote occurs on the McGovern amendment. Those in favor will say aye. Those opposed, no. Opinion chair, the noes have it. The noes have it. Clerk, call the roll.
Mr. Sessions.
No.
Mr. Sessions, no. Ms. Fox. No. Ms. Fox, no. Mr. Bishop, no. Mr. Woodall. No. Mr. Woodall, no. Mr. Nugent. Mr. Nugent, no. Mr. Scott. No. Mr. Scott, no. Mr. Webster. No. Mr. Webster, no. Mr. Reed. No. Mr. Reed, no. Ms. Slaughter. Mr. McGovern.
Aye.
Mr. McGovern, aye. Mr. Hastings.
Aye.
Mr. Hastings, aye. Mr. Polis.
Aye.
Mr. Polis, aye.
Do I get to vote?
Mr. Chairman.
No. I vote no.
Mr. Chairman, no.
Clerk, report the total.
On that, there were 3 yeas and 9 nays.
And the motion is not agreed to. Are there further amendments? Mr. McGovern.
Mr. Chairman, a number of members, both Republican and Democrat, offered thoughtful amendments to this bill, and I believe they should be allowed to offer them on the floor. I I move that the committee make an order and en bloc and provide any necessary waivers for amendments numbers 2, 3, 4, 6, 7, 8, 9, 10, 11, 12, 13, 15, 16, and 17.
We're not going to ask for an explanation. Vote occurs on the McGovern amendment. Those in favor will say aye.
Aye.
Those opposed, no.
Ask for recorded vote.
Clerk, call the roll.
Mr. Sessions? Mr. Sessions, no. Ms. Fox? Ms. Fox, no. Mr. Bishop, no. Mr. Woodall? Mr. Woodall, no. Mr. Nugent? Mr. Nugent, no. Mr. Scott? Mr. Scott, no. Mr. Webster? Mr. Webster, no. Mr. Reed? Mr. Reed, no. Ms. Slaughter? Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis?
Aye.
Mr. Polis, aye. Mr. Chairman?
No. Clerk report the total.
On that, there were 3 yeas and 9 nays.
And the motion is not agreed to. Are there further amendments? If not, the vote occurs on the motion of the gentleman from Dallas. Those in favor will say aye. Those opposed, no. The ayes have it. The ayes have it. Clerk, call the roll.
Mr. Sessions?
Aye.
Mr. Sessions, aye. Ms. Fox? Ms. Fox, aye. Mr. Bishop? Aye. Mr. Woodall? Mr. Woodall, aye. Mr. Nugent? Mr. Nugent, aye. Mr. Scott? Mr. Scott, aye. Mr. Webster? Mr. Webster, aye. Mr. Reed? Mr. Reed, aye. Ms. Slaughter? Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings?
No.
Mr. Hastings, no. Mr. Polis?
No.
Mr. Polis, no. Mr. Chairman?
Aye. Clerk report the total.
9 yeas, 3 nays.
And the motion is agreed to, and this will be handled by the gentleman from Florida, Mr. Nugent, for the Republicans.
And the gentlelady from New York, Ms.
Ms. Slaughter will be managing. And Chair will be in receipt of a second motion.
Thank you, Mr. Chairman. Mr. Chairman, I have a motion for H.R. 1213 and H.R. 1214. Mr. Chairman, I move the committee report one rule for consideration of H.R. 1213 to repeal mandatory funding provided to states in the Patient Protection and Affordable Care Act to establish American Health Benefits Exchanges, and H.R. 1214 to repeal mandatory funding for school-based health center
Mr. Chair,
construction.
I move for unanimous consent to dispense with the reading.
Well, I suppose we can do that if you'd like. Okay, everyone understands the rule that's before them? Let me just explain it. Without objection, we'll dispense with the reading. We have a modified open rule for the consideration of the school-based measure, and we make in order all of the amendments that were submitted that comply with the rules of the House were either we did not make an order of the amendments that were not germane or complied with CUTCO. Are there any amendments to the rule?
Yes, Mr. Chairman.
Oh, Mr. Hastings.
Chairman, I move the committee make an order en bloc and provide any necessary waivers for amendments numbers 2, 3, 5, 6, 7, 9, and 10.
You've heard the motion, gentlemen. As I said, those are amendments that are non-germane and don't comply with CUTCO, so I'm going to urge a no vote. Those in favor of the Hastings amendment will say aye. Those opposed, no. Pin the chair, the noes have it, the noes have it. The motion is not agreed to. Are there further amendments?
Recorded vote, Mr. Chairman.
Clerk, call the roll.
Mr. Sessions?
No.
Mr. Sessions, no. Ms. Fox? No. Ms. Fox, no. Mr. Bishop? Mr. Bishop, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Nugent? No. Mr. Nugent, no. Mr. Scott? No. Mr. Scott, no. Mr. Webster? No. Mr. Webster, no. Mr. Reed? No. Mr. Reed, no. Ms. Slaughter? Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis?
Aye.
Mr. Polis, aye. Mr. Chairman?
No. Clerk report total.
3 yeas, 9 nays.
And the motion is not agreed to. Are there further amendments?
Yes, Mr.
Oh,
Chairman.
Mr. Hastings.
Mr. Chairman, before offering the amendment, just one very brief comment, and it will be brief. To repeal mandatory funding for school-based health care centers, in my opinion, is one of the most incompassionate or uncompassionate, I'm not certain which is correct. I just find it mind-boggling that we are in a position to not be supportive of this measure. I move that the committee report an open rule for consideration of H.R. 1213 so that all members have the opportunity to offer amendments to this bill.
You've heard the motion of the gentleman. Any further discussion? If not, the vote occurs on the Hastings amendment. Those in favor will say aye. Those
Aye.
opposed, no. The chair, the noes have it. The noes have
I
it.
ask
Motion.
for a record.
Clerk, call the roll.
Mr. Sessions? No. Mr. Sessions, no. Ms. Fox? No. Ms. Fox, no. Mr. Bishop? Mr. Bishop, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Nugent? No. Mr. Nugent, no. Mr. Scott? No. Mr. Scott, no. Mr. Webster? No. Mr. Webster, no. Mr. Reed? No. Mr. Reed, no. Ms. Slaughter? Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Yes, with emphasis.
Mr. Hastings, aye. Mr. Polis?
Aye.
Mr. Polis, aye. Mr. Chairman?
No. And the clerk report total?
3 yeas, 9 nays.
And the motion is not agreed to. Are there further amendments? Mr. Polis.
Mr. Chair, I'd like to submit to the record, without objection,
Without objection,
Crowley
we
of New
include in
York.
the record.
Yes, Mr. Crowley of New York, a fine statement. Mr. Chair, I have an amendment to the rule. I move the committee grant H.R. 1214 an open rule.
I think we just considered that.
12, that was 1213. This is 1214.
Okay, well, that's fine.
This one I'm confident will
We
come
have a
out a different
modified
way.
open rule that's being made in order into this. The vote occurs on the Polis amendment. Those in favor will say aye.
Aye.
Those opposed, no. Opinion of the chair, the noes have it. The motion is not agreed to. Are there further amendments? If not, the vote occurs on the motion of the gentleman from Dallas. Those in favor will say aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes have it. The motion is agreed to. And Mr. Reed will be managing his first rill for the majority, and Mr. Polis for the minority. Thank you all very much. Let me just say that our meeting will be held at 3 o'clock tomorrow afternoon on the Natural Resources Bill.
Wednesday.
Oh, excuse me, Wednesday. Sorry, Wednesday.